Hello and welcome to this April webinar. My name is Dominic Moss and today we'll be dealing with GDPR and Data Protection Act 2018 for PI lawyers. The webinar is going to be over three parts. The first part will be looking at some basic principles of the Data Protection Act, how things have changed and the sort of data that personal injury lawyers collect and what is lawful processing. In part two, we'll be looking specifically at subject access requests under Article 15, the need to appoint a data protection officer, and the interplay between that and lien and professional privilege. In part three, we'll be looking at some other obligations and principles and policies that we all need to undertake to make sure we're compliant. We'll be looking at some Article 30 processing registers, how long you keep data retention policies, that kind of thing, whether you can process marketing lists from people that you've sold to previously or dealt with previously. So without any further ado, we'll crack on with part one. What's changed? Well, lots changed since 1998. The amount of data that we all keep has grown exponentially, and all the places that it's stored, it's the same. In order to cope with all that data, the Act and the GDPR tries to enhance our obligations to deal with it by giving us enhanced obligations of recording of the processing, impact assessments where they're needed, where there's a high volume of data being processed, enhanced rights for data subjects. We've all heard about right to be forgotten and subject access requests. Increased powers of the Information Commission, again, that's something that's already been in the papers a lot, is the 4% of worldwide turnover potential fine. It's gone up from the current £500,000. The accountability principle, that's the principle where you have to actually show what you're doing is compliant, so there has to be written records for many of the things that we do. There's the obligation to introduce technical and organisational measures to keep data more secure, so looking at your systems. And some organisations, like the big ones, will need to appoint a data protection officer. So back to basics, what is personal data? Well, personal data is information relating to an identifiable living person. So that person is called the data subject, and the information has to relate to them. So the first port of call is, does it relate to them? Second port of call is, are they alive? Because if they're not alive, GDPR doesn't apply. Then they have to be identifiable. So if I was to say to you, I'm talking today about a Scottish nurse with Ebola, you'd probably all know who I was talking about. The identifiable aspect makes personal data quite a broad topic. It can even include things like cookie code, because the cookie code that it was collected from you when you visit a website could be able to contain your IP address, and the IP address is personal data in many circumstances. So personal data is a very, very broad thing. Special personal data is a narrower thing. It's what we used to call sensitive personal data under the old Act. It includes racial origin, political opinions, religious beliefs, sexual life and orientation, and health is obviously a big one for personal injury lawyers. Two new items for 2018, genetic and biometric data. So if you've got some fancy system for getting into your building, you'd be processing potentially biometric data. Okay, the core principles that GDPR is built on are contained in Article 5. There's 7 of them. Basically, first thing, everything has to be lawful, and that's not lawful in the sense of GDPR, it's lawful in the sense of all laws and regulations. The data has to be processed fairly and transparently. Purpose limitation deals with only using that data for the purpose that you intended to use it for when you got it. You can't just simply get some data and decide, oh, well, actually, I could do something else with this. Data minimization, do you really need that data? I think the ICO's website has a video where somebody goes into a hotel and the hotel receptionist says, what's your shoe size? And that's a good example of data they don't really need. When you do collect data, it's got to be accurate. So any inaccuracy could be a potential breach, so make sure what you've got is correct, and it's only kept or retained or stored for an appropriate level of time. Security, massively important under GDPR. It's specifically mentioned. We'll talk about that later. And accountability is the idea, as I said, of keeping a tab on what it is you're doing and why you're doing it and being able to prove that to the ICO should you get a knock on the door. So, Principle 5. What does the ICO say about it? It says, well, this principle should lie at the heart of your approach to processing personal data. So if you keep that in mind, you probably won't go far wrong. So who are the players? What's the data controller? Well, the data controller is anybody who collects personal data. The data controller will decide the means, have the means and decide the purpose. So the means is the data, the purpose is what you're going to do with it. It includes non-natural persons, such as limited companies. In fact, in most cases, it probably is going to be a limited company that's processing the data. And if there's two of you processing it, and your relationship with Facebook may be a joint controller relationship, then that's what's called. It's data share between two controllers who both control the means and the purpose. What's a data processor? Well, a processor is a data controller is often the processor as well, but sometimes you're just a processor. And in those circumstances, it's the person acts on behalf of the data controller. They'll have the means, but they won't decide the purpose. So the controller will basically tell them what to do. Now, they can't act without the written authorization of the controller. And a good example of this relationship is outsourced payroll. You send out all the information relating to your staff to an outsourced payroll person, and they then get that information and give it back to you in a usable format for doing your payroll. The person doing the outsourced payroll would not then be expected to use that data for their own purposes. Now, there has to be a written contract. This is in GDPR, Article 28, and that has a number of obligatory provisions. So you need to think about what relationships you've got with data processors and make sure that you've actually got the obligatory provisions in a contract between the two of you. If it's a bigger organisation, you'll probably find that it's already been done for you. But if it's some smaller organisation, just make sure that that is a legally binding contract between the two of you and it's in writing. Now, this doesn't include the staff of the data controller, so if you're shifting data from one part of your business to another, you don't need to worry about a processing agreement. So what do we all process? Well, rather boringly, we all actually process pretty much the same as everybody else. The one I always like to flag up is emails, because they're a bit of a nightmare. People send you data, you don't ask for it, they send it to you, and it might even be, quite sensitive data. The other one that's obviously massively relevant to PI firms are going to be health records. And it's not just the records we get in, it's also the fact that we talk about people's health and we'll have file notes, etc., relating to their health and barristers' opinions and all the rest of it. So in order to process this data, you have to have a grounds under GDPR, and there are 6 grounds, and if you haven't got one of these, you're out of the game as processing is concerned. So the first one is consent. Consent has to be fully informed and freely given. Now, this was talked about a lot before GDPR actually started, and people almost talked about it as if it was the only ground. And in reality, it's the ground you want to avoid if you possibly can, because it can be withdrawn at any time. The main ground for processing clients and staff data is going to be contract. You're either entering into one or you already have entered into a contract, and that is going to be your ground for processing the data. When that person becomes a non-client or a non-member of staff, you've probably still got a legal obligation to process that data, and that's dealt with in Article 6.1c, gives you grounds to process that and continues to do so. Vital interests, well, if you get a phone call in the middle of the night and it's somebody desperate, it's a life and death situation, you can provide the data. Public interests, probably that's going to apply if you, maybe law reports, that kind of thing. What I want to move on to quickly is legitimate interests. Now, this is where the data controller has a legitimate interest in processing the data. And by that, I don't mean just got it kept in a laptop in a cupboard. You actually do have to have an interest in doing it and processing it. That interest has to be weighed with the rights and freedoms of the data subject. So it's not just good enough that you want to process that data, but you have to bear in mind those freedoms of the data subject. Now, an example is it may or may not apply to direct marketing depending on the circumstances, but if for example, you've got clients and you want to send out to them some information about PI Trust, they're ex-clients, you've settled a case, and you think they really should know about this, that might be a case, if it's done 6 months after the case finished, that where that would be a reasonable thing to do. It might be in their legitimate interest. It wouldn't be too onerous upon them, at the end of the day. If, however, 6 years after the claims have finished, you decided you wanted to email all your clients about a new venture you have selling sheds, then that probably wouldn't be in their legitimate interest. So it's finding where you lie between those two. The data subject has a right to object at any time. If they object, pretty much most of the time you're going to have to stop processing it under this ground. There are exceptions to that, but pretty much most of the time you will have to do that. Now, this doesn't apply to special personal data. The health data we talked about, you're going to need a condition on that. And moving on to special personal data, Article 9 of GDPR says, well, can we process it? And the answer is no, you can't. It's prohibited, which would make life very difficult for PI lawyers were it not for the fact that there are some conditions which allow for processing. And you must always have an Article 6 ground, anyone will do, but you will need an Article 9 ground to process those, shall we say in this case, health records. Fortunately for PI lawyers, the Article 9.2F provides that you can do that if it's for the establishment, exercise and defence of legal claims. So anything you're doing in relation to getting your client's case either from the beginning or potentially after, if you want to keep it for the defence of a legal claim, could be covered by that. Consent, if you've got a client you want to put a photograph on your website and it's of their face because they've got scarring or something and they've given you consent to do that, then you'd need Article 9, explicit consent. And by that we mean that the consent has to be explicit to that particular processing activity. It can't be a general consent given for all their, sort of personal data. So it would have to be explicit in that sense, so they knew what they were consenting to. Excuse me. Okay, so another ground for processing special personal data is for carrying on your employment obligations. So members of staff, etc., you're okay under Article 9 to B. And there are some others. Vital interest is mirrored in Article 9 as in Article 6, so life and death situations. Manifestly made public, if it's just been put out there by the data subject, then you can continue to do so. There's no point in you keeping it a secret if it's already out there. And if it's for substantial public interest, and that might apply to continuing to hold special personal data on your files after the case is finished in cases of, for example, an inspection from the SRA. Now, we all from time to time get process criminal offence data. It isn't special personal data in the same sense. It's kind of extra special personal data. There are different rules in relation to it. You still need an Article 6 ground. So if you've got a seeker client and you're wondering what offence you've got their offence data, or you just have that for some other reason, you're going to need an Article 10 condition in this case, and that's at the schedules to the Data Protection Act 2018. There is fortunately one that deals with legal proceedings, so you can carry on processing it. Some of the conditions in the schedules require you to document a policy in relation to this kind of processing, and it's probably best to make sure that where you are doing this, that you've actually got a policy document demonstrating that you've thought about the grounds, etc., and why you're doing it. So that's part one. Moving on to part two, this is the subject access request part. What is a subject access request? Well, under Article 15, the data subject has the right to obtain from the controller the confirmation as to whether or not personal data concerning him or her are being processed. That's not too onerous, but the next bit is where they want access to that data. Now, we mustn't forget that we're only talking about data that relates to an identifiable individual here. So a SAR request is not a request for the whole file. So you don't actually have to send your client or ex-client your traffic signals information that you've obtained as part of their case, because it won't be personal data relating to them. There's normally a charge, there is not normally a charge for this. Article 12.5 says it has to be free of charge, but there are some exceptions I'll come on to. You have to respond to your SAR within, used to be within 40 days, and that's now changed, it's down to 30. Now, you can extend that by up to 2 months from the 30 days, so it's 3 months in total. And that's where the requests are particularly complex or numerous. And it's for the data controller to decide whether that's the case or not. If you do decide that that's the case, then you're going to need to notify the data subject within the first month that actually, you know, just saying, can I have all my personal data, has led it to being a complex and numerous procedure, and you can't do it within the 30 days, and you're going to have to take your 3 months. Now, this is useful in a way because it's a negotiating tactic. So if you get just the, people often think, well, you know, I might as well just ask for it all. If I'm going to ask, I'll ask for it all. But if you can go back and say, well, you know, if you want it all, it's actually going to take me 90 days because that's a very complex thing you've asked for. What is it actually you really want? Well, I really only wanted the medical report. Well, actually, if you want that, I can give you that within 7 days, no problem. So it's a way of actually going back to the data subject and negotiating with them and maybe reducing the burden upon you for complying with the SAR request. You do have to know what relating to means, of course, because if it doesn't relate to the data subject, you don't have to give it to them. A very important case on this, it's an old case, but it's an important one, is Durant versus the FSA. Mr. Durant was a financial services provider, and he got into trouble with the FSA, and they kept a big file upon him. He wanted access to that file. It was decided under the old rules, but there were similar provisions, and it's still applicable. Now, in Durant, in essence, cutting to the chase, they looked at relating to and decided really that it was quite a narrow definition. Old LJ, Lord Justice, looked at it and he said that really, I love this bit actually, he said that not all information retrieved from a computer search against an individual's name will be personal data. Mere mention of the data subject in a document held by the data controller does not necessarily amount to his personal data. He then looked at two sort of notions that might be assists, and one was, does it have a biographical significance? And the other one, what was the focus? And if we're thinking about medical report for a minute, obviously, you know, client's medical report is going to have biographical significance to the client. But if you've got a data subject to ask a request from the doctor that had written it, it wouldn't necessarily, the focus wouldn't be on them, apart from maybe the CV bit at the end. Now, this has moved on a little bit since Durant, as you might expect, what relating to means. The ICA has lots of guidance on the website and lots of examples, and I think they're worth a read. The case of Fifium at 2014, they looked again at Durant and decided it was probably a bit narrow in scope in respect of what relates to meant, and said it was really decided on its own grounds, and in that case the scope was broadened somewhat. But there isn't actually a post-GDPR case yet for us to look at. The other problem that we have is that personal data tends not to be discrete, and very often the documents contain the personal data of a number of parties. And if we look at, again, at, say, a medical report, it's going to have the doctor's personal data, it might have personal data relating to a member of staff, there may be a carer involved as well as the actual individual. If it's a child's medical report, again, there may be a parent's data in there also. So what does the Data Protection Act say about that? It says, well, where a controller can't comply without disclosing the information relating to another individual, the controller is not obliged to comply with the request. Unless, and it's the unless that's the devil in the detail, you can get consent. And if you can't get consent, you have to think, is it reasonable in all the circumstances to comply with the request without the consent of that third-party individual? Now, Durant again, they looked at this and they decided how do you balance the competing rights of the SAR requester and the third-party data subject. And they looked at it and decided that actually the balance was in favour of non-disclosure. So if you couldn't decide affirmatively that this was something that you should be doing, the balance was don't disclose the data, don't disclose the documents relating to the third party. As you might expect, things have moved on a bit from Durant, and in the case of B versus GMC, decided under the old rules but only this year, good Dr. B was being looked at by the GMC in respect to his fitness to practice. There was a medical report on him and he wanted to see it. The clinician who had undertaken the report didn't want him to see the report, and apparently he would have known exactly who it was just by reading the report, so it couldn't even be redacted. The problem there was decided about the balancing of these competing rights of the data, third-party data, and the subject and the data subject acting for the SAR, and it was decided in that case there was actually no presumption in favour of non-disclosure, so they went against Durant, and I think that's now the case. It's more of a level playing field. So a balancing act, what do you do? Well, you've got to do this balancing act between the competing rights of the two parties if you get one of these SARs come in. There is no presumption in favour of non-disclosure. You must consider the facts of each case. Look at the code of practice on the ICO website. Now, in the event you've done all that, you've considered the competing rights of the two parties and you've still come to the conclusion it's a 50-50 split, well then the tie-break is in favour of non-disclosure, but that was considered to be, in the recent case, a very unlikely scenario. The DPA says, well, you can't actually construe all this as an excuse for not providing disclosure. So no matter what you feel about disclosure, there may be ways of being able to do it by redacting, getting rid of the identity of the other party, omitting names, etc. But it can't just be a blanket excuse. The ICO in their code of practice says when you're making these decisions, you must do it on a case-by-case basis. This is not the subject for a blanket policy. We're holding it, and we've all seen that, haven't we? We can't disclose this to you because of data protection rules. They haven't even thought about the process. So let's look at some examples of when PI practitioners are in this position. We've talked about the medical report, and it might contain third-party data to other people, relating to other people. You've got to consider all the pros and cons. But in that case, if it's the actual person who the medical report is about asking for a copy, you'd think it was going to likely to weigh in favour of access to it because it was made for them in any event. But think how different that might be if it's the doctor that wrote the report for whatever reason wants a copy of it. You'd have to think, well, actually, do I give a copy to him? If he hasn't got a copy now, maybe he shouldn't be having one. Perhaps all I would release to him is his name at the end and the part that relates to his own CV. Other examples, file notes. Two solicitors talking in an office about a broken leg. It might be relating to a case. It might be more to do with general information about just how much a broken leg is worth. Is that going to be personal data? Well, it depends on the conversation, I suppose. Depends on whether it was intended to be confidential or not. So you might have to think about that in doing your weighing up procedure. If there's a complaint in the offing about that solicitor and whether or not he valued the case correctly, then of course that data might be said to relate to him, and that's in the ICO website. It says this: if it's the quality of their work that's under scrutiny, the data could well be said to relate to that person. So that all needs to be taken into consideration. CFA, well, a few of us have received requests for copies of CFAs. Now, do you have to give this over if the request is made by a SAR? Now, this is not exact law, but my viewpoint is it's a long document. The client's name may only be at the beginning of the document and the end. If you took that away from it, there would be no way of identifying the client from the rest of the document. So can it really be said to relate to them? It's certainly a starting point. It's certainly an arguable starting point if you do not want to disclose your CFA, but you receive a SAR asking for it. So, you know, if you get you've got a legal lien off a client, legal lien on a file, and you get a request for the file in total, and you don't want to hand it over, things to think about is what is the documents relating to the client. You don't have to hand over the rest, the traffic light information, for example. You can redact those bits that relate to third parties potentially. Might be a witness statement made by somebody who wasn't the client in relation to the claim, who won't give consent. Would it be fair to hand that over anyway? There's a lot of exceptions under the Data Protection Act and the schedules at the end of it that you could go through. I haven't got time to go through all those today, but they're definitely worth looking at. Tipping off is one, and negotiation exception is another. Legal professional privilege actually is another exception at Schedule 220, although it's not on the slide. There's guidance on the Law Society website who owns the file, and that guidance was recently mentioned in Hanley versus JCNA and mentioned very positively. There is also the potential for an exception if the document has already been given to the person asking for it. You may be able to charge for that document. So a lot of things to think about before simply handing over the file. So this is a subject that two sides to this subject. How long do you keep medical notes after the file's closed? Well, there's those people that think we'll keep them all in case there's a complaint or we get sued. And then the other part of it is, well, what are the dangers of keeping it and the obligations of keeping it? So if you decide to keep all that data, those medical notes, and not just the notes on your case management system, but there might be paper notes as well, then of course you could argue that that's for the defence of any potential legal proceedings you're keeping them. But you have to bear in mind you've got an obligation of data minimisation, and you couldn't really be said to be doing that if you're keeping mountains of somebody's medical notes 4 years after a claim has ended. You can always erase them, get rid of them, and ask them again if you need them. So, you know, is there really a need to be keeping all those notes? If you do decide that you want to keep them, then there is an obligation to provide access to them if you get a SAR. So if you get a SAR from somebody saying, I want all my medical notes from you, you're going to have to give them, because there isn't really an exception to that. Obviously, if you got rid of them, you don't have to do that. And the other big one is if your notes, you've got held them electronically and you get hacked and you've got 1,000 clients' notes suddenly in the internet, it's a bit of a nightmare. So think very carefully about policies on keeping medical notes. So can you charge for a SAR? Well, the answer to that is no, but if there has been a previous request, maybe you can. That charge is based on your normal admin cost, so it's not the 10 quid you have to charge prior to it. That's the only little bit of good news. You can actually say, well, it's taken me half an hour and this is what I'm going to charge you. I mentioned there again the time to comply, 3 months in total, a month initially, and some of those exceptions if you want to refuse. And it's always worth a look in the back end, the schedules of the Data Protection Act, to see whether one applies, because there's quite a few in there. The data subject doesn't need to send it to you in a sort of Martin Lewis money supermarket type way, specific format. If they ask for it, that is good enough. Be careful though, you get the right ID to make sure that you're dealing with the right person, and if you're dealing with a child, be careful, because it might be the parent asking for it, it might be an estranged parent, and you need to be sure that that's the child's wishes, especially if the child has got over 13. You might want to 13 is age of consent for children to this type of processing. Ask the child if they want their notes given to someone else. Word to the wise, if you have notes in your filing system, which this client is an absolute nightmare, not a good idea, because it is an offence to alter, deface, block, erase, destroy or conceal information with the intention of preventing disclosure. So if you get a SAR and such a note exists, don't be tempted to get rid of it. And the sort of person that is making a SAR is also probably the sort of person that would report you for that, and it's a criminal offence, and it'll get you into a lot more trouble than if you actually just have to bite the bullet and send the document to the data subject. Best thing here is to make sure it doesn't happen. Have procedures in place within the office that such notes are not made, and if they have been made in the past, it's best to get rid of them before you get the SAR. So this is a circumstance where we get we've probably dealt with where insurance companies refuse to hand over the details of their insured driver. Now, this is one where you want the information off the insurance company, and they won't give it to you. Now, if you ask for a SAR on behalf of your client in respect of this, they will have to give you all the data it relates to your client. Now, there are the exceptions I mentioned before, but there may well be data in there that isn't subject to an exception that they would have to comply with. And actually, I found that if you actually make a SAR when they're playing this game, if you make a SAR on the 2 cases we've done it on, they've actually come back with the data that we actually really wanted, which was the defendant's name and the vehicle registration number. You've got to remember that this is actually a legal obligation for them to provide this data, so them saying to you, oh, there's data protection issues is just not correct. Similarly with clinical negligence cases, if you've got an agency, medical authority not providing notes on the grounds that it contains third-party data and they don't want to give it to you, and they can't get a consent of a doctor because he's moved out of the country, which is one we recently have. Okay, they've tried to consent, they have to prove that they've actually sought consent for disclosure. So it's good practice, and that's there in the SRA Code of Practice. But they have to do the balancing act, and it isn't good enough to not actually do the balancing act. Is it okay? Is it reasonable in the circumstances to provide it? So what I'm saying really is if you get a blanket response, push a little harder. Witness statements, other records, human resources records, similar accidents, witness statements that are taken at the time of an accident in a factory situation, for example, may well contain your client's personal data. They have to consider whether or not to redact it in full, or whether it's reasonable to give it to you or not give it to you at all. So it's not a good enough response to say we can't give you the statement of the chap that gave a statement because of data protection, because they have to go through the process. They have to ask for consent. It's good practice. They have to then, if they don't get consent, and they may well get consent, who's to say that person doesn't want their statement to be out there, but if they don't get consent, they still have to do the balancing act and consider redaction. If they just fast forwarded straight to we're not giving it to you, well, that's not good enough. So on to part 3. Take a quick drink. Doing quite well for time. So appointing, these are things that you have to do. We all have to do to comply with GDPR. We're going to go through here. So appointing a data protection officer. Not all of us will have to do this, but you must do it if your core activities include processing on a large scale of special categories of personal data. Well, I'll take core activity as read because if you're a PI firm, it's going to form part of your core activity. Special personal data is medical records, so tick that box. Large scale is the one we need to look out for. There's no definition of large scale. Earlier drafts, the Working Party 29 documents talked about 250 employees, maybe 5,000 records, that sort of thing. There's a lot of difference in PI cases between having 5,000 records and having 250 employees, but you have to think how does it apply to us? If you decide you need a DPO, then that person's going to need to have an expert knowledge of data protection law. It's not just a case that you can just nominate somebody from the office to deal with it. They're going to have to monitor your compliance they're going to have to advise on impact assessments. Now, we're not talking much about impact assessments, but these are the things that you need to undertake if you're doing something different, if you're sending out a marketing campaign, changing your case management system, dealing with new people and sending documents out to them. You might want to decide what are the enhanced risks that are flowing from this new activity. They deal with SAR requests. They can't be a member of the board, they must be independent. Obviously, you know, if they're a member of the board, there's pressure can be put to bear on them to overlook data issues if it's inconvenient. They have to try and avoid a conflict of interests. So it's the marketing manager, for example, they might be, you know, from putting on their marketing manager's hat, more than happy to actually send out 5,000 emails to previous clients, but putting on your data compliance hat, you might not think it's such a good idea. So it's best to choose somebody that doesn't have those conflicts. Now, you can outsource this activity, and that's not always a bad idea. Somebody come in and do your audit for you, somebody there who's very into the fact that that's what they do, they have the requisite expert knowledge, that they can monitor this on a monthly basis. If you do need an impact assessment, they can do that as a bespoke thing. So there are firms out there that can help with outsourcing of data protection compliance. If you decide you don't need a DPO, but you want to assign somebody to the task, don't call them a data protection officer, because if you do, then they will be subject to all the same obligations as a data protection officer. It would be taken as a voluntary data protection officer person. Call them something else like data compliance manager, similar name, but try and keep in mind all those roles and the fact that they need to be independent. And obviously they need training, they need to have the time and the training to be able to deal with the job effectively. So what is the first job, whether you're a DPO or a DCM, let's say DPO from now on, you need to do a data flow mapping exercise. So you need to look at who's collecting the data, where's it from, what you're doing with it, who you're giving it to, and what are the grounds for maintaining it or processing it in the first place. How long are you going to keep it, and is it going to be safe while you've got it? So all that information needs to be put on a register. You definitely need to do this if you're a DPO firm. If not, it's a very good idea, because it will actually highlight the blanks or the pitfalls in what you're not doing. So the register includes a number of matters, which is going to be the details of the data controller, the purposes of processing the data, details of any recipients, so where you're sending it to, maybe medical agencies, details of transfer outside the EEA. Well, this could be us next year. We could be outside the EEA. And you need to know that where it's going and whether or not it's safe when you send it there. A lot of people think they don't send their data outside the EEA, but most storage facilities for the cloud are outside the EEA. You take your phone on holiday, you send emails abroad. So all of us will be doing this at some time or other. The time limit for data to be erased, you need to be thinking about that, and that will be on your processing register, and the categories of data you're processing. And with respect to each category, you need to put the database in place to maintain data security. Now, there's a template on the ICO website that deals with this. It's 30 columns long. It's a bit unwieldy. We've pared it right down, and I think ours is still compliant, but if you want to be absolutely 100% certain, you can use the ICO template. So other records that you might, when you've gone through all this, you'll come across some holes in what you're doing, and you might think, well, actually we need a data retention policy. This is about how long we're keeping the data, how long why have we decided to keep the medical notes for 7 years or whatever. When do we erase it? What's our policy on that in relation to different types of data? Your legitimate interests, if you're marketing using the legitimate interest processing, then you might decide that you want that to be in a policy notice that you can refer to, and that will explain your grounds why you believe that is in the legitimate interests and does not overrule the rights and freedoms of the data subject to your or marketing to. Consent, it's a good idea to have that down. What is consent? How is it obtained? What do you mean by consent? How is it given? What's your policy in relation to withdrawal consent? How do you deal with keeping records of that? How are the records of explaining their right to withdraw consent? How is that given to the data subject? Remembering it must be given at the time consent is given, not down the line. Talking again about international transfers, if you're doing this, it's best to have that down there. Article 44 to 50 of GDPR, so it's a big subject. This is 6 of the articles deal with it. Look at your server space. Where is that held? You'll probably find that a lot more of your data is sneaking outside the EEA than you thought. Where we are next year, we might become a third country next year, so there's another problem that may arise after March, depending on how Brexit pans out. Principle of data protection by design and default, another one you need to be thinking about. It's very close to the heart of GDPR. You need to protect against unauthorised processing and accidental loss, destruction and damage. Make sure that doesn't happen. You've got backups in place. Use appropriate technical and organisational measures. So, anything that goes out, laptops, encryption, passwords, make sure things are encrypted. I think iPhones are automatically encrypted, but laptops, make sure you've got secure passwords. A laptop getting stolen could be an absolute nightmare. In respect to the physical elements to this, locks on your office, clear desk policies and phone to work policies. How much do you allow people to access emails on their own phones? What do you do when that individual walks out the door to another practice and has still got 3 years worth of emails on their phone? So very, very important that you look at these things on a regular basis. Regular penetration testing, get your IT company to look at that, or there are other companies that offer this service on a yearly basis to make sure that you're not at an open gate for hackers. Do that data audit every year, because things change and you'll need to make sure that your processing register changes with it. Consider whether you need insurance. Breach insurance is out there. It'll pay out in the event that you've got data breach somewhere and you may need to change your systems, or there's a malware situation going on. It can be very handy to have the backup of some insurance. So how long do I keep the data? This is the retention policy. Article 5 GDPR says don't keep it any longer than is necessary. Now, that's not massively helpful, but you remember you always must have an Article 6 reason for processing the data, and consider what I was saying about medical records and the obligation for data minimisation. Sometimes you might not need the entire file. Sometimes you might be able to minimise the data that you actually hold about somebody and still be able to comply with your own needs and any lawful legal obligations you may have. Talking again about technical and organisational measures while you do decide to keep it. Remember, change of purpose. Now, this is quite something that people forget about. You have your data initially because it's a contract. You've got a contract with your client, you're running a claim, and all is good. But after the contract is finished, the client's gone away, you're then processing that for tax reasons maybe, or the potential for an SRA investigation. Well, after 6 years have gone past, after that reason has evaporated, are you then still got any reasons for processing it? So you need to be aware that those reasons may go away and you may not have another purpose for keeping that data. The legitimate interest argument isn't going to work simply because it's useful to have data. You might need to look back at a certain case. Isn't going to really cut it, I'm afraid. So privacy standard, you've probably all heard about privacy policies or fair processing notices. These are what now seems to be called the privacy standard. They're dealt with a number of obligatory provisions that must be in them, and it's dealt with in Article 13 and 14 of GDPR. I won't go through the entire list now because it's quite long, but if you go to those articles, you'll be able to see what needs to go in your processing privacy standard. Respect to website, they have their own issues. Again, most people have a website privacy policy. I think that's a good idea. You don't necessarily want all your privacy standard available to the public, but remembering that people need to have access to some of that information prior to giving consent, for example. You must have it in a place that's fairly obvious, and the website is usually the good place to do it. That needs to contain a lot of the things that are in Article 15 and 16, so again, look through there. Cookie policies are exactly the same. Cookie policies are no different to a normal privacy policy. People keep them separate because really it's a different type of data. It relates to technical stuff. You may have a grid full of all the cookies you've got on it, and it doesn't make your actual privacy policy a very easy read if you stick a cookie policy in the middle of it. But in reality, they are the same, coming from the same place. That should be on your website, and you really need to decide what is your cookie policy, and that's going to depend on how you collect data on your website as to how you allow people to turn on or turn off cookies. And you can contact me about that later. It's a bit of a thorny issue, to be honest with you. Contact management systems, not every website, but a lot of websites, especially WordPress websites, have got CMS systems behind them which have a nasty habit of keeping a load of data for a long time. I've been to companies where they've forgotten all about them, and they've got years and years and years of data relating to people who have contacted them, given their mobile phone numbers and names, etc., and it's just sitting there in the back of the content management system. Needs to be thought about in relation to your data retention policy. Web forms, if you get clients or potential clients to fill in a form and send that off to you, you want to reply. Well, obviously it makes sense to that it's going to be in their legitimate interest to reply. So you don't need consent here. It's one of those times where the legitimate interest grounds for processing is going to apply. So if they email you, you can email back to them. But how long can you do that for? So you could do that maybe for a few weeks or months, as long as it was about the initial request. But if you wanted to actually contact them a few years down the line, or contact them about some other service that you were offering, then you couldn't do that possibly with the legitimate interest ground. So you need to consider whether or not you add a ticked opt-in consent button to your web form. I think it's probably useful to do that and to have all the reasons you're doing it, the policy in relation to that, in your website privacy policy. And then if people give consent, you can then mark it to them or contact them until they withdraw that consent, or you consider that consent's no longer valid. Always a good idea to keep your policy on a link to the policy on a social media site. If you use Facebook, you've probably got clients on Facebook who are friends of the practice or whatever. Well, there is a place there to put your policy links, and don't forget to mention Facebook or whoever is your social media platform of choice in your privacy policy document. Conditions for consent, you need to be able to demonstrate where consent was obtained from, and obviously that goes back to the privacy policy and the type of consent that you obtained and what it was for. You need to need clear language. If it's aimed at a child between the ages of 13 and 18, has to be appropriate to a child that age. It can't be gritted teeth consent, so asking your staff to consent to marketing to them is a no-no, and it can't be linked to a refusal to provide service. So saying to a client, well, we need consent to put your picture on our website. If you don't provide it, we can't actually act for you. That again is a no-no. So consent can't be linked to the provision of a service. You must be willing to provide the service, and that would include parts of your website, by the way. Provide the service that relates to those parts of the website without asking for consent to process data. Consent can be withdrawn at any time, so that right to withdraw must be communicated clearly to the data subject at the beginning, which is, as I say, it should be in the privacy policy. You need to keep a record of withdrawn consents, which again is a good idea to have withdraw and subscribe buttons on your emails, and try and make it as techy as possible so that those consent withdrawals are kept automatically to avoid an administrative burden of having to do this by hand. A little case I'd like to talk about, it was Honda getting in trouble with the ICO 2017. The irony of this, it was actually Honda were sending out an email saying, would you like to hear from us? Well, unfortunately, one of the people that received the email didn't want to hear from Honda, so they dobbed them into the ICO. Now, the Honda was saying that, well, PECA applies here, and PECA is the Privacy and Electronic Communications Regulations, which I'll come on to next. But there's the concept of a soft opt-in, which means we can actually market to our old clients. But the problem in this case is that they weren't their old clients. The list had come from their franchised independent dealers, so PECA didn't apply. There was no consent. The legitimate interest issue wouldn't have applied anyway, and Honda were in a breach situation, so they received a fine, notwithstanding the fact that they're actually trying to get their ducks in a row for GDPR. Talking about PECA, as I say, Privacy and Electronic Communications Regulations, they were supposed to be changed at the same time as GDPR came in. It didn't happen. There's some idea that the soft opt-in was going to be changed, but we don't know about that yet. PECA applies to emails and all electronic communications, including phone, but not post. So you can still write out to people without considering PECA. And you've got to remember that PECA applies differently to communications to businesses and individuals. Now, the consent for PECA consent, the ticked opt-in, has replaced now the unticked opt-out. So if you're relying on an opt-in, it still has to be ticked opt-in like the GDPR standard. The soft opt-in still applies for now, but remember that they must be clients of the same data controller. As I say, this may all change next year, depending on Brexit, depending on what PECA 2 says, or e-privacy regulations, as they will then be called. So if you are using the legitimate interest ground to market to your old clients and PECA's soft opt-in, is that okay? Well, the answer is it may be. And I'll point you to recital 47 of GDPR, which says the processing of personal data for direct marketing purposes may be regarded as carrying out for a legitimate interest. And as I mentioned earlier, it's all going to be to do with context here. So whether or not you've dealt with them before, have you dealt with them before in relation to the items that the services you're currently offering, the time between dealing with them and the time you're sending out the email. So something that actually APIL have asked me to deal with specifically, and this is for all firms who are APIL accredited or going through the accreditation process or are going to be re-accredited. PI files, by their very nature, contain personal data. You're going to need Article 6 grounds and you're going to need Article 9 grounds to give those files to a third party to audit in some cases, and it will apply to Lexel, APIL, or medical agencies or the like. Now, APIL sent out to all members in May, I understand, some information about how to get your clients to provide the relevant consents, and there's some wording there that you need to be asking clients to agree to give consent at the outset of the case. So in the event of an APIL audit, you can let APIL see the files. So if you haven't got that information, then by all means contact APIL and they'll resend it out. And I understand now they are going to resend it every year when you reapply, so that people are reminded to ask clients for that as they go along. Worth just mentioning that this is not required for audits by the SRA or the tax authorities, because that would be assisted by the condition for public interest, so they could rely on that and they wouldn't need consent from the data subject. Now, as I mentioned, APIL will be sending out some information about this, but if you were doing it yourself, the consent needs to be clear and it can't be linked to other consent. So the general consent of marketing, for example, could not be covering the consent for handing over the files for this purpose. It should be a specific consent, standalone. You know, I'm happy to give my files to be audited by April. I understand that that's a good thing because you know, they're making sure the case has been run well, that sort of thing. So, take a quick sip. What happens if it all goes wrong? Well, the meaning of a breach is that where there's destruction, loss, alteration, unauthorised disclosure or access to personal data. This is the nightmare scenario where you have an unencrypted laptop go missing and you have to notify the SRA that there is a significant risk to the rights and freedoms of the you know, 4,000 clients that you've got on it. The notification has to be within 72 hours. It doesn't matter if it's a bank holiday weekend, and even if the ICO isn't open, you still have to send them the notification. And you also have to consider the need to notify the data subject if there is a significant detrimental effect to them by all their medical records going to some unknown third party. And you can imagine the reputational damage that this is going to do to your business. If you do have to tell the ICO, you need to tell them the categories of the individuals that have been affected, the categories and numbers of personal data records affected, the name of the poor soul, the DPO is going to be dealing with it, some of the consequences that you envisage might flow from this breach, and the measures that you're currently taking to try and sort it out. Always wise to have a plan in advance, because if you do, you'll probably see the pitfalls before they arise and you won't end up in this situation. Okay, so finally, summary and first steps. You need to appoint a DCO or a DCM, somebody to look after your affairs for you. Get them to do that audit and complete the register, Article 30, which is available on the ICO's website. Think broadly about where your data is and you know, cookies, websites, and all that kind of thing. Where do you keep data hidden away? It's usually lurking somewhere you don't necessarily think of. Make sure you've got lawful grounds, especially for that data that's been hidden in a cupboard. Can you still process it? Should you be getting rid of it? And when you've done all that, there should be a load of gaps. Some small gaps might be very difficult to fill, and you might find you've got some big gaps in there that are very easy to fill. So that's it from me. Lastly, keep calm and comply with your GDPR obligations. I think April wanted me to say that the next webinar will be avoiding problems with limitation and the effective use of Section 33. That's on the 7th of November with Gordon Exall. So unless there's any questions, so the question is to particularly, well, I'll have to get back to the second one. Can you send an email regarding a client that identifies a client to a third party who has an interest in the client's claim, e.g. defendant or their solicitors, or another example, potential expert in the case? Yes is the short answer to that. You're processing the data with under the terms of your contract with the client. It's necessary for the performance of that contract, and it's going to be necessary, the personal data that you might contain in there is going to be covered by the legal interests, Article 9 provisions. So I think we've run out of time, so that's it from me. Thanks everybody for watching today and as tuning in, as they say, and I hope you enjoyed and learned something from it. Thank you.